Welcome to this QLTS School podcast with Oliver Brettle, the London office managing partner of global law firm White & Case. White & Case LLP is a leading global law firm with lawyers in 38 offices in 26 countries. Among the first US-based law firms to establish a truly global presence, White & Case provide counsel and representation in virtually every area of law that affects cross-border business. In this podcast, I discuss with Oliver why English law remains the preferred jurisdiction of choice for cross-border transactions, the continued dominant status of English law, and the opportunities available for international lawyers seeking to qualify as English solicitors via the Qualified Lawyers Transfer Scheme. You may experience some distortion in audio quality due to internet connection problems. We apologise in advance for any inconvenience or disruption to your listening experience that this may cause. Thank you very much indeed for taking the time to speak to us, and I'm grateful to you for that. Now, White & Case is a US-based firm with a strong London presence. What factors do you see as being key to White & Case's success in establishing and maintaining a presence in a competitive legal market?
I think we are recognised by our clients as having three distinctive qualities which together make us stand out as different. First of all, we are a truly global law firm. If you look at the relative size of our New York office against our London office and our global presence, you'll see that our New York office is a good size, but it doesn't dominate numerically like you'd find at many other international law firms. But we set ourselves on the path of going international a long time ago. I think we were the first US firm ever to open up in France in 1922. You've got offices such as Brussels, which I think opened in 1967. We've got London, which opened in 1971. We've been international for a long period of time. And we have therefore got a true pool of good quality local US and English qualified lawyers to help our clients achieve their business ambitions in today's world. Secondly, we are renowned for navigating complexity, by which I mean we don't tend to do much in the way of bread and butter work in London. Of course, we always have to do that. But what we do is work on some of the most difficult and challenging matters which may be facing our domestic and multi-jurisdictional clients. And then lastly, and I think this is something which really comes from the US heritage as much as anything else, we are deeply committed to understanding our clients' legal, commercial and cultural needs. Our clients appreciate how we look out for their long-term interests and create enduring and trusting partnerships.
And how does London and provision of services in English law generally form part of White & Case's operation and growth strategy?
Well, to be quite blunt, it is absolutely core to our growth strategy. I was having a conversation with Xiaoming Li, who is the partner in charge of our Beijing office. He was saying to me that 75% of all international finance transactions in the Beijing market are governed by English law. If you go to our Moscow office and you talk to the partners there, they will tell you that many of their most important and substantial project financings, financial transactions, etc., even within Russia, are governed by English law. You are seeing a whole host of deals and matters which have nothing to do with the physical islands of Great Britain, but which are governed by English law because that's the law of choice of international clients for their deals globally. And obviously, as the importance of English law in cross-border transactions, as well as disputes, continues to grow, the London office being the repository of the largest number of English law lawyers within White & Case, the London office plays a central role in advising our clients on English law through the various different countries in which English law deals are happening at the moment.
And you recently spoke with Legal Week about the increasing importance of English law as the preferred jurisdiction for cross-border transactions and disputes. And you've touched on this by saying that the vast majority of transactions in Russia and China, for example, are under English law. And in your experience, Oliver, why is English law so highly regarded by clients?
Well, first of all, I think it's probably got a lot to do with history. How did English law get there in the first place? Well, it got there in the first place because of trade, particularly maritime trade, with Lloyd's of London providing insurance contracts globally, which were governed by English law. Therefore, bills of lading were governed by English law. Therefore, the ship contracts were governed by English law, and it sort of grew from that sort of base, I suppose. Maybe it's a question of looking at common law versus civil law. Generally speaking, the civil law jurisdictions are perceived to be more rigid, less flexible, and with more in the way of implied terms and restrictions on the freedom of the parties to contract as they will. So really then you have a look at the common law jurisdictions, and one of the principal ones being English and US laws. And I think there is an element of clients worrying about uncertainty, particularly with jury trials and the like in the US, and therefore opting for the greater certainty of English law, the respect for the English legal system, and the judgments which are handed out in London. So I think it's a combination of these sorts of factors. I'm not denigrating any particular legal system. I'm just trying to explain why it may be that English law has sort of taken off, as it were. Well, I think it's quite interesting to note that the firm has roughly, and it is only roughly, 550 English law qualified lawyers, and half of these sit in London, with the other half located around our network of global offices.
From what you know of the QLTS, Oliver, or I should say the Qualified Lawyers Transfer Scheme, what is your view, and indeed if you're able to speak from other people's experiences, the market's view of dual qualified English solicitors at this stage?
I think it shows versatility. I think, for example, if an Australian or New Zealand qualified lawyer wants to be seen to be perceived to be a fully fledged English law lawyer, then there is the expectation that they will have the English law qualification as well as the qualification from their home state. It's useful from the perspective that dual qualified lawyers can work in different countries and are more mobile. As I've just been saying, our English law expertise is spread globally. It therefore, as night follows day, if you're an English law qualified lawyer, our ability to use you globally is obvious.
What role, Oliver, do you envisage dual qualified solicitors can or do or will play in international law firms?
Well, I think this really goes to the whole issue of English law as I discussed earlier. We are talking about people becoming English law qualified. That's where the demand is. And, we have the focus to spread and enhance our English law capacity around the whole firm. Obviously, though, when we're doing that, it's useful and appropriate that we have English law qualified lawyers who reflect the diversity of our firm. Diversity is something which is very important for White & Case, and I think encouraging that diversity by having people from various different legal backgrounds becoming English law qualified and then adding to the overall diversity of the firm to reflect the diversity of our clients and their origins, I think that's for the good of the firm and for the good of the individuals.
Do you feel dual qualification is a worthwhile step to consider for internationally qualified lawyers?
Abundantly, yes. That links straight back into my growth of English law comments, the fact that English law is used on international deals. You can say this to an extent with New York law, as a New York law qualification, the same sort of concepts apply. But the demand for German qualified lawyers outside Germany is really pretty small.
Mm-hmm.
The demand for French law qualified lawyers outside France is small. It's not as small as German, because of course some very large French companies, when they may be contracting with Francophone Africa, may well govern their contracts by French law, and or they will be dealing with legal systems in countries which are derived from the French legal system. So that can be a help. But generally speaking, no law is more spread out than English law, and therefore, if you wanted to be an internationally qualified lawyer, English law is a fairly good choice to pick.
How do you feel dual qualified lawyers can best leverage their dual qualification status?
This is a difficult one, because I think there's an assumption sometimes that people continue to practice both areas at once. Generally speaking, that doesn't happen. Generally speaking, people find it hard enough to keep on top of one jurisdiction's legal developments than two. Okay?
Mm-hmm.
So generally speaking, they will become more used in, say, English law than the original law that they qualified in.
Mm-hmm.
But that's a generalism, and there may be exceptions, and I know that there are, for example, finance lawyers in various parts of the world who will advise on local finance deals from time to time, but when it comes to the larger ones and their international aspects and it's covered by English law, they can advise on that too. But generally speaking, over time, people tend to end up concentrating on one rather than the other. But in terms of leveraging their dual qualification status, it really is a case of more playing on their backgrounds, their experience, their roots into their clients, etc., rather than continuing just to say, oh, I am dual qualified.
Mm-hmm. No, I agree with that. I mean, we're finding a lot of the candidates who are taking the exams aren't actually looking to practice in England. They're looking to practice in their home jurisdictions or home countries.
Absolutely. And if you look at White & Case in, say, Warsaw, we've got 2 English law qualified finance lawyers there. We've got individuals in many of our offices who have sort of just gone back to their homeland, for want of a better term, qualified in English law, practicing English law, and working out of those offices.
That's really helpful, Oliver. Thank you very much indeed for taking the time to speak to me about it.
Well, not the way. And thank you for the call. It's a very unpleasant time on a Friday afternoon for you, evening for you.